Welcome dear learner. You are welcome on this SWAYAM platform and we are dealing with the course Understanding Competition Law Theory and Practice. I am your instructor Dr. Mayank Pratap, Assistant Professor, Faculty of Law from Banaras Hindu University. We are dealing this course from last 7th module and we are in 8th module of this particular course. And today we'll take up the second session of this last module. Under this module, we have to discuss the authorities under the Competition Act and the enforcement mechanism. So in this session, we have to discuss particularly about the duties, power and function of Competition Commission of India. Just going into detail, if you remember the previous session, we have discussed the Competition Commission Act is an act to promote the competition in the market and to prohibit the anti-competitive activities, to curb the abuse of dominance and to regulate the merger and amalgamation like combination, to promote the competition by advocacy. So, for the purpose of these objectives, there are certain authority. For the purpose of execution of the object of this act or to enforce the mechanism or to regulate the concept for the purpose of the enforcement of the mechanism given under this act, there are certain authorities which are responsible. That means to promote the fair competition, to prevent anti-competitive practice, to protect the consumer interest, the enforcement mechanism are primarily administered by the Competition Commission of India, Directorate General, National Company Law Tribunal, and sometimes with the reference to the central and state government. That means if you see what are the authorities under the Act for the purpose, the authorities are CCI, DG, National Company Law Tribunal, and central and state government. So additionally, the Act provide mechanism for grievance the redressation, address the violation of the ensure accountability under this Act. So authorities what we have discussed, and in last session we have started the discussion over the first and utmost important authority, that is CCI, and in last session we have discussed there are the certain provision regarding the establishment of the CCI. We have discussed under section 7, the composition of CCI we have discussed in section 8, and the other provision related to the terms of condition and service like 8, 9, 10. So in today's session, we will discuss the duties, power and function of the Commission. Actually, the Commission is principal regulatory and adjudicatory authority under the Competition Act 2002 and tasked with promoting fair competition, preventing anti-competitive practices and safeguarding consumer interest in India. The CCI's duties, power and functions are comprehensively outlined in the Act, particularly in section 18, 19, 26, 27, 31, 33, 36, 41, 46, 48A, 48B and the section 49 and have been enhanced by the Competition Amendment Act 2023. So let us start with the duties. We will discuss in three aspects, that is duties, power and function. So let's start with the duties of the Commission. That is not specifically on the name of the duty, but the duties as distributed within the sections, we have compiled it for the academic discourse. So for the purpose of academic discourse, the duties of Commission may be categorized into 2 points. First, duties under section 18 and the second, the duty towards international cooperation. So if you see the section 18, subject to the provision of the Act, it shall be duty of the Commission to eliminate practice having adverse effect on competition, to promote and sustain competition, protect the interest of consumer and ensure freedom of trade by other participants in market in India, provided that the Commission may for that purpose of discharging the duties or performing its function under this act, enter into any memorandum of or agreement with the approval of the central government with any agency of any foreign country. Duties of CCI, if you see, the main objective of competition law is to promote economic efficiency, using competition as one of the means of the assisting the creation of market responsive to the consumer preference. This was observed in the case of Ramakant Kini versus H.L. Hiramandani Hospital 2014. The Competition Act is aimed at addressing the evil affecting the economic landscape of the country in the which interest of the society and consumers at large is directly involved. One of the objective of this act is to promote consumer welfare by preventing market discourse or disorders caused by the action and agreement of the enterprise which militate against the competition and consumers' interest. The competition law, by its very nature, envisages that there are situations where the commission has role and has to control behavior of the enterprise in the market. Commission has a role in control behavior enterprise to achieve the consumer welfare, and which was discussed in the case of Excel Corporation Care Limited versus Competition Commission of India in 2017. Section 18 of the Act, which is in consonance with preamble of the Act, cast an obligation on the CCIs to eliminate anti-competitive and promote competition, interest and consumers and free trade. That was discussed in case of Samsher Kataria Informant versus Honda Steel Car India 2014. The exercise of power under section 18 is subject to other provision of Act in the Bel Air Owners Association versus DLF India case 2012. And for the purpose of reference, I have cited the taxman.com 435. You can access this document from where it has been referred. It was stated that the aim of the commission is to institution of a system of undistorted competition, which is Competition Act and section mandate the commission to protect the interest of consumer, and it is important to ensure that consumer's surplus is not adversely impacted. The second important duty is that lies in the international cooperation. If you see, the commission may enter into any memorandum of agreement with prior approval of central government with any agency in foreign country. As mandate under section 18, if you see, under 2002, the commission entered into memorandum of understanding after obtaining approval of the government of India with the following authorities till March. This is a list till March 2019, where the CCI has entered with the like the FTC, Federal Trade Commission, Department of Justice with USA, Director General Competition, European Union, Federal Anti-Monopoly Services with Australian Competition and Consumer Commission, Competition Bureau with Canada, and Competition Authority of the Federal Republic of Brazil and Russian Federation. So with this duties of the commission, if you see, there are number of the duty which may be regarded as the duty, like competition advocacy, promotion of competition. So we will discuss in some other aspect, but let's start with the power of CCI. What is the power of Competition Commission of India under this Act? If you see, the CCI is endowed with a wide array of quasi-judicial, investigative, remedial, regulatory and administrative power to enforce the Competition Act effectively. These powers enable the CCI to investigate, adjudicate, penalize and regulate market conduct. Section 36 is specifically related to the quasi-judicial power. The CCI has the power to civil court under the 1908 for the purpose of discharging the function, which include the summon and attendance of witness, examining them both, requiring discovery on production of the document, receiving evidences and affidavit, issuing commission the examination and witness or document. Inspecting documents and records are the other quasi-judicial power under the section 36. The CCI can regulate its own procedure under section 636 clause 2, providing flexibility and education while ensuring the fairness. So, as the power given to the CCI for the purpose of evaluate the power or discussion the power, this you may say this is a category what we have prepared for the sake of understanding, like investigative power, quasi-judicial power. So part B, what we are going to discuss, that investigative power. What are the investigative power of the CCI? It lies in section 19, 26 and 41. Section 19 is about the power that is initiation of inquiry. The CCI can initiate inquiry into suspected violation of the Act. It may be suo motu or based on the complaint from any person, consumer or other associations. Upon reference by central government, state government or authorities, the CCI assess whether there is a prima facie case of contravention under section 26A, and the CCI is empowered to ask to the Director General or to Director General to give direction to investigate in the matter for the purpose of gathering the fact and evidences. That means it is basically the power of CCI. When CCI initiate any matter for the purpose of the inquiry and CCI is prima facie on the view that there may be susceptibility or the possibility or appreciable adverse impact on market in India, CCI may initiate inquiry by the direction given to the Director General for the purpose of submitting of report, which may include the fact, circumstances, data, the third party report or any kinds of the substance or relevant matter for the purpose which is related or anyhow to assess the possibility of the impact of the appreciable adverse impact, whether it is not or whether it is towards the Indian economy, market, competition in a relevant market. So this is the power of CCI. The CCI assess whether there is a prima facie case under section 26, then CCI may direct to the Director General, and if a prima facie case is established, the CCI direct to a Director General which is appointed under section 16. We have already discussed there are certain the authorities, and the second authorities after the CCI what we have discussed earlier, that is Director General. So we will discuss in other aspect the role of the DG, appointment of DG, but just for the sake for general information, DG is a important aspect as a enforcement mechanism under the authorities which is appointed under section 16. For that purpose, it will lead to the investigation under section 26 clause 1 if it is directed by the CCI. Now the DG has the power akin to the civil code section 41, and we will discuss the DG's power within the next step. But for the purpose of the CCI power, it is important to know that when DG submits an investigation report, CCI reviews to make final determination by the section 26 clause 7. What are the remedial powers of the CCI? If you see, the remedial power of CCI lies in section 27, 28, 31 and 33. The anti-competitive agreement and abuse of dominance in case section 27. That means upon finding violation of section 3 anti-competitive agreement or section 4 abuse of dominance, then CCI can issue ceases and desist order to stop the anti-competitive practice, impose penalties up to 10% of average turnover of enterprise for the preceding 3 years, direct modification of agreement or practice to eliminate appreciable adverse impact on competition, or division of dominant enterprises, which is under section 28, where CCI can order the division of a dominant enterprise to prevent abuse of dominance, such as splitting business units. Or this is rare. It happens rarely, but it happens, and it is basically the power of CCI, and CCI may exercise this power under section 28. So, what we are discussing today is, in this session, that the most important, not you can say the powerful is a term which is not relevant, because powerful is what powerful? They have power which has been assigned by the act. He is only exercising the power provided by the statutory. So, there is nothing like the powerful, but yes, powerful in the case of execution and mechanism, which is an important aspect, because it is only the CCI who is appointed and established under this act to enforce the objectives of the act. That's why CCI is an important aspect, and what we have discussed, there are a specific power and the powers are distributed in different statutory provisions. So, for that understanding, we have discussed the power of the commission is like the quasi-judicial power, the remedial power, and the other power. We have discussed the basic object or role of CCI is to prevent anti-competitive activities, to curb the abuse of dominance, to regulate the merger and amalgamation, to promote and sustain competition, fairness, equal level field. For that purpose, CCI have to regulate by the exercising statutory provisions and the powers given under this act. And CCI is, while exercising, CCI may take decision and CCI may inquire into the matter. And it is not only CCI not only on the fact or basis of any complaint if they received by information, it is CCI who may suo motu can take any action of the initiation of inquiry under section 19. Section 19 empower CCI to take action to initiate inquiry, and if the CCI is satisfied that any proposal or any complaint or any activities of abusing of dominance is like whether it may hamper the consumer interest and will appreciably adverse impact on market, CCI may take appropriate action and issues the appropriate order under section 31 or impose the penalty. That's why we have discussed the penal provision, what the penal provision in the case of anti-competitive agreement and abuse of dominance, and the penalties provision are given under section 27, whether he may commission may impose the penalty up to the 10% of average turnover of enterprise preceding 3 years. So now this has become the important power and function of the commission. The commission, one of the most important aspect of regulation of combination, what we have discussed in the previous module, that is in section 31. For merger, acquisition or amalgamation under section 5 and section 6, the CCI can even approve the combination if it does not cause the appreciable adverse impact on competition. CCI may propose the modification to mitigate the competitive concern. CCI may prohibit or block the combination if it is CCI believe on the basis of the fact, on the report submitted by the DG, on the basis of the response of the parties, or by anything if CCI finally analyzed and found that if it causes the appreciable adverse impact. So the review process is an important process, but the important thing is CCI have to conclude its review within 210 days as per section 31 clause 1. But yes, you have to remember that it's not 21 days. Initially it was 21 days, now it become the 150 days. Even CCI may issues an interim order under section 33. Now, during the inquiries, the CCI can issue temporary injunctions to restrain anti-competitive practices if they risk causing irreparable harm. The CCI's remedial power are comprehensive, but the division of enterprises, section 28 for that purpose, is underutilized due its complexity. So, interim orders are effective but require clear justification to avoid judicial scrutiny. That means interim order is a power of the commission, what commission may exercise, but the important thing is it may only be effective, but it requires the justification to avoid judicial scrutiny. Now, what are the penalty power? Section 27, 47, 43A, 44 and 45, some of we have already discussed, that the CCI can impose monetary penalty for the contravention like violation of section 3 and 4 under section 27 up to the 10% of the average turnover for preceding 3 years. Non-compliance with CCI order under section 43 up to Indian rupees 1 lakh per day for non-compliance. Failure to notify combination under section 43A, that is up to 1% of total turnover of asset, whichever is higher, that is gun jumping administration. False statement or omission, if there is, under section 44, CCI may impose the penalty up to rupees 1 crore, and in case of furnishing false information under section 45, CCI may impose the penalty up to 1 crore. So this is the penalty power which has been with the CCI. Now another aspect, leniency and settlement power, which is one of the most important aspect of the power which is dealing with the CCI under section 46, 48A and 48B. Leniency program is an important program. We will discuss into detail in another session, but for today's perspective, it is important to know that leniency and settlement powers are lied with the CCI under section 47, 48A and 45B. So, leniency program is given under section 46, and the CCI can grant reduced penalty to enterprise that provide full, true and vital leniency program. Disclosure about the cartel activity, because the leniency program is a program that is for the purpose to reduce the penalty to enterprise, and it is in the case where the information is full, true and vital about the disclosure of the cartel activity. Like this is a program, whistleware program you can say, and in 2023 amendment, the expanded leniency to cover facilitator to cartel is that hub and spoke arrangement, and it allow application even after DG investigation, encouraging whistleblowing, and we will discuss in another session the detail of the leniency program. Now the settlement and commitment, the section 48A and 48B. It is introduced by 2023 amendment for abuse of dominance cases. Commitment, section 48B. Enterprise can offer to modify practices within a specified timeline to address competition concern. Settlement under section 48A. Enterprises can pay penalty to close inquiry without admitting guilty. So these mechanisms expedite the dispute resolution and reduce litigation. So what we have discussed, there are some power, even you can say there are various power lies with the CCI, and CCI may exercise the power as per the statutory provision provided under this act. But apart from these power what we have discussed, there are some other power. Other power, that means the power which are distributed in some other with the help of the regulation or the statutory provision. One of the important power I would like to discuss with you people, that is dawn raids under section 41. Through the DG, the CCI can conduct unannounced inception to resize evidences of anti-competitive practices, a critical tool for cartel investigation. So these are the power. What we have discussed today is the power and function. Function is not another thing. Function is that execution or exercising the power. Power lies with CCI, and CCI, how CCI utilize this power and exercise this power. This is basically the function of CCI, to exercising this power in the interest of consumer interest, in the interest of the promotion of competition. So, power, you can see the inquiry by the CCI, what we have discussed already. The section 19 of the Act permit the CCI to conduct the inquiry. It empower the CCI in case of anti-competitive section 3 and section 4 abuse of dominance. The source of information, basically what we have discussed, the initiation of inquiry by the complaint, but it is not mandatory that complaint must be by the informant or otherwise. It may be suo motu, that may be by person, consumer and their association. So, we have already discussed the inquiry procedure, and this inquiry procedure is basically the exercising the power, and this exercising the power is basically the function of the CCI. So, for that what we are discussing, that it is not only the statutory power, there are certain regulations, particularly regulation 2011 and the regulation of 2011, the particular is regulation 10, 11, 12, 13, 15, 27, which is about the content of information, signing the information, procedural for filing information. These are the regulation which is an important aspect, which is important for exercising the function and exercising the power to operate it function by the CCI. And the, of course, reference from statutory important authorities and important, as per section 2W, the statutory authority means any authority, board, corporation, council, distribution, university or any body corporate established under the central state government under the Act, purpose for regulating promotion, goods provision, therefore matter connected in incidental thereto. So they may be statutory authority. And one of the most important function is like determination of appreciable adverse impact on competition. So though CCI is powerful, CCI has its power to analyze, but the function is to analyze these assessment on the basis of the parameter given under section 20 subclause 4. So with this, in today's session we have discussed what are the duties, power and function of the commission, and in next session we will discuss the other authorities like Director General and the mechanism, power enforcement mechanism under this Act. So with this, I am leaving this session today. Thank you.